The case is now being recorded.
Right. This brings us to the sixth and final case on our hearing list today, case number 2020P 364, Joseph Chalafu versus Jamie M. James and others. Mr. Chalafu, you may begin.
Thank you, Your Honor. I first want to just thank you for giving me the opportunity to argue like this. It's actually quite an honor, especially as a pro se litigant. So I appreciate that. You know, I had wrestled with how to compress such a lot of information into just 15 minutes. And I still haven't arrived at a good way to do that. So I think I want to just, I guess, sort of talk as if I'm just talking to another individual and maybe touch on some salient points, but, you know, ultimately I would rely on my brief. I think the lower court, I think, did some legal gymnastics as a way to dismiss this case. I think that there's a lot of novel issues here, and I think it warranted a lot more consideration than it got. I think anti-SLAPP was more than loosely applied to a lot of my claims, and I think as evidenced by the lower court literally not even addressing some of my various torts and using anti-SLAPP to release some litigants in the case in the way that it did, as I had brought New Hampshire torts against them under diversity jurisdiction. It literally, at least as far as I can see as a pro se litigant, there is no vehicle to use anti-SLAPP, a Massachusetts defense for a New Hampshire tort. You know, I'll further say there's to read the.
Let me I guess start by trying to frame the your claims of error. You've identified one very broad suggestion and one more narrowly focused one, namely the New Hampshire based tort. But I guess let me start by asking you: which claims that were dismissed, if any, do you contend were not based on petitioning activity?
Thank you, Your Honor. Well, a number of them. First and foremost, malicious prosecution. I think this was a textbook claim. I think it met all the criteria precisely, and I think it had no business being.
Well, but prosecution by its nature is an action brought in court, and so that would ordinarily be considered petitioning activity. Whether it is devoid of any basis in fact or law, it seems to me is a separate question. So I guess in this organizational exercise, I would like you to identify those claims that you contend were dismissed that did not rest on petitioning activity.
Defamation, slander, libel, false light.
The statements on which those claims are based, how and where were they made?
They were made from private individuals to other private individuals, two or more. They were published in writing, and Where were they published in writing? In various emails and letters and verbally published to others as well.
Can I ask the same question that Chief Justice Green is asking, but maybe through a slightly different perspective? Can we just take for the moment whom I'll call the law firm defendants? Okay, the lawyer and the law firms, the lawyers and the law firm. Just them for the moment. Are you alleging anything about them, against them, that they did outside of the conduct of litigation?
Yes, ma'am, absolutely.
Okay, what specifically?
Assault and battery,
That's fair enough. That happened in the context of, in the courtroom.
Yes.
But you say that's not a litigation activity. Is there anything other than that that your claims are based on, that you say they did that was outside the conduct of litigation?
Yes, Your Honor. They threatened numerous individuals who I had a contractual relationship with.
The court reporter?
Yes, ma'am.
Okay.
And the GAL.
And the GAL. Okay, so that all took place in the context of court proceedings.
Yes.
Okay, so is there anything, I just want to go back to my question so that,
Sure.
It seems to me if all of their actions, setting aside the assault and battery, took place in the context of litigation, then at least with respect to them, the claims look to me like they're based on petitioning activity. The issue then becomes the next prong of anti-SLAPP. So maybe you want to talk about that.
Yes, absolutely. Thank you. Well, that brings me back to malicious prosecution. And I certainly understand what Chief Justice is explaining. And I guess your point of the context is really important. This was simply, and I'm not going to go into all the particulars, but the nature of what it was, the evidence that they proffered actually proves my point that they knew what they were saying was false. They simply did it as a way to harass me and injure me. And I think it fits that. I think it puts it squarely outside of anti-SLAPP. In fact, there's one point of the lower court judge's order that's interesting. She says that the assault and battery clearly isn't part of petitioning activity. And I think what's important here in a lot of this context relative to anti-SLAPP, and that's not all I want to talk about, and my time's halfway gone, but clearly there's legislative intent. Just because, for instance, you're a lawyer, I think that's a tacit admission by the judge that it doesn't mean you can just do anything because you're in a court or you're representing somebody. I mean, you can't, and I know this is, well, not even too much of an extreme example. You can't just go punch the opposing counsel in the face because you're a lawyer in the courtroom. So I think a lot of what they did was wildly outside of that. And so I think they fail on that second prong.
Okay, and the second prong, we review for what? Do you know what our standard of review is for the second?
Yeah, it's devoid of any, I just had it, my finger hit the thing. It's the claim being devoid of intent. I would.
Reasonable basis in fact or law.
Yes.
We review that for abuse of discretion. I think we review to see whether the judge abused her discretion in determining whether the claims lacked such a basis.
Yes, ma'am.
Okay, so you're saying that she did? Absolutely.
Yeah. Yes.
What about for the non-lawyer parties? Can you
Sure.
say what it is, what acts your claims are based on against them that you say are not petitioning activity?
Absolutely. And that's really even the larger part of this case, which is what was so troubling to me, that this was all lumped into anti-SLAPP. So much of this has to do with my ex-wife, not all of it, much of it, a lot of the claims against her have to do with her contacting her personal friend, Sean Woods, on a police department. Okay. Never made out a police report, contacted him on Facebook and on his personal cell phone. And it went on to have an intimate relationship with her and him. They cooked up a scheme together, and it seemed to be a quid pro quo, sexual in nature, for his services as a cop. To harass me. They cooked up this scheme that I was dealing illegal firearms. And I'm not going to go too far into that, but I was never charged with anything. I have no criminal record. It never happened. They said I was doing it out of my girlfriend's house, who lived in Tingsboro, Massachusetts. Mr. Woods finally mobilized his police friends. Okay. It was only after this was done in a personal capacity, mobilized his police friends, searched my girlfriend's house against her will. The statement, all the affidavits are there. The phone records are there. He was taking pictures, literally searching her underwear drawer, taking pictures and sending them to my ex-wife. Now, this is in the same vein as like the assault that the judge, a lower court judge, admits isn't part of anti-SLAPP and not part of being a lawyer, essentially. These acts were wildly outside of anti-SLAPP. This was my ex-wife partnering with a personal friend. And these are facts I'm talking about. I deposed him in my divorce. He admits that she contacted him on Facebook. He admits they're friends.
Is there a search warrant for that search?
No, absolutely not. No, it was wild what happened. And, you know, again, another tort I bring is MGL 172. It's using public databases, and her and this cop used this database to use my information, get my information. He gave private information to her, and it says right in the statute, right in MGL 172 and 176, there's no defense.
Do you have a full citation for that? There's usually a chapter and a section.
I do. Well, it's in my brief, and I apologize.
I looked for that. You just said GL 172 through 177 or 179. But
172 through 175 are the different violations, and 176.
Is that the chapter or is that the section? And if it's sections, what chapter are you talking about?
I don't have it in front of me, Your Honor. I'm sorry. I'll be happy to supplement the court with that information, but it specifically says there's no defense. It says it right in the information. I apologize. I didn't have it available. I didn't think I'd be asked that. But so these acts were wildly outside of this. And I also say this in my complaints. One of the people involved, as I went to pick up my children one day and I had guns pointed at my head from the SWAT team. Well, now her live-in boyfriend is Charles the Charon, #2 in charge of the Nemlec SWAT team, the same people that were pointing guns at my head. I mean, this isn't protected activity. This is outrageous. And, you know, this wasn't an anti-SLAPP motion they filed. It was a motion for summary judgment. It meets the criteria for that. So the court erred there, again, by allowing it as an anti-SLAPP motion. This is notice pleading, most of these things. The things that need to be pled with particularity, I did so. But everything else is notice pleading. I should be entitled to discovery. Clearly, if these facts happen, as I say, I would be entitled to relief. These aren't things that I'm just doing to chill her ability to litigate or whatever. These are outrageous things that happened to me that could be proven in very short order if I could just get a tiny bit of discovery. The lower court judge talked about our divorce order, but yet she failed to mention how the lower court judge said that the defendants used a scorched earth approach. The lower court judge failed to mention how all of the backstory I gave, where in New Hampshire, my ex-wife's own law firm dumped her for Gail back east. You can look it up on the New Hampshire disciplinary things. She was disciplined for making false offers of proof in court. In her defense with the disciplinary committee, she wrote up a statement saying that her client lied to her, and she saying I dealt drugs and everything. This has been a decade or more of lies involving all these people. My ex-wife's father telling friends and family that I poured white powder on his garden. It's just outrageous lie after lie after lie. It cost me my ex-girlfriend, my family, my children. It's insane, and I've never been able to break the seal of just discovery. These are organized, an organized effort to hurt me. It failed in New Hampshire, so they moved it to Massachusetts, where they've had great success, and I've never been able to have any discovery at all.
Mr. Chalfo, that brings your time to an end. We hear your concerns, and we certainly have your brief, and we will look through these issues very carefully as we review your brief for what we didn't reach in this argument. Thank you.
Thank you very much, sir. Thank you.
Okay. For the appellee, who's going first?
I'm next for Law Office of Jamie Moritz James and Jamie Moritz James individually.
Okay, you may begin.
Okay. Good afternoon, justices. May it please the court. My name is Ivana Epperson Temple, and I represent the appellee's Law Office of Jamie Moritz James and Jamie Moritz James individually. This case is about harassment by litigation and retaliation for petitioning activity. As Superior Court Judge Tutman noted, this case is part of the plaintiff's extended pattern of engaging in repetitive, seemingly never-ending, and retaliatory litigation in an effort to harass and further exert control over his ex-wife. This case represents 3 of 7 lawsuits that the plaintiff initiated against anyone and everyone involved in the plaintiff's divorce, no matter how minor their role was, including Jennifer's attorneys.
I don't mean to do that statement, but that doesn't really match up with the requirements of the anti-SLAPP statute. You know what I'm saying? The anti-SLAPP statute, the bulk of the case was dismissed on the basis of the anti-SLAPP statute. And at least the way I understand that statute, we need to look claim by claim to see whether the claims that the plaintiff brought were based solely on, we just need to go through the framework. We need to first determine whether they were based solely on petitioning activity, and then if they were, whether they were completely devoid of any basis in law or fact. And that part of the analysis was not really done claim by claim in the judge's decision. So can you tell me what we're supposed to do with that?
Well, the judge's decision lists a number of grievances that the plaintiff had against my client, all of which concerned petitioning activity, whether or not it was statements written or oral made during judicial proceedings, whether or not it was statements made during settlement discussions, and that is also considered petitioning activity based on the Plant v. Wiley case. All of it has to do within the scope of my client's legal representation of Jennifer. And this analysis of whether or not something solely concerns petitioning activity was conducted in the recent May 2021 Haverhill STEM LLC versus Jennings appellate decision. And that decision supports Judge Tutman's decision here in determining that all of the complained of activity, aside from the assault and battery, concern petitioning activity. Most importantly, it's clear that the plaintiff failed to meet his burden under the anti-SLAPP statute. He's failed to show that my client's petitioning activity was devoid of any reasonable basis in fact or arguable basis in law. He's failed to show that he suffered any type of actual injury as a result of my client's petitioning activity. And he's also failed to show that the multiple lawsuits that he initiated against my client were brought for any reason other than to chill my client's petitioning activity. And as such, for those reasons, Judge Tutman's decision is correct and should be affirmed. But beyond the anti-SLAPP, there are additional reasons supporting dismissal of the plaintiff's claims, including the absolute litigation privilege and the fact that my client owed no duty to her client's adversary. With respect to the privilege, to the extent that the plaintiff is arguing that any of the statements or communications that my client made during the underlying divorce litigation are actionable, such statements are protected by the absolute litigation privilege. Those statements and communications arose out of my client's petitioning activity in the divorce litigation and were made while the attorneys were acting in their function as counsel for Jennifer. And as such, there is a full and absolute and complete defense to liability there. In addition, with respect to any duty argument or negligence-based argument, there is no attorney-client relationship between the plaintiff and my client, nor has one been alleged. In addition, there is no indication from the record that the plaintiff relied on the legal services that my client performed on behalf of her own client, Jennifer. And this, based on the plaintiff's complaints, was the focus of everything in divorce litigation, given
Judge Wolahojian is trying to break in with a question.
Oh, excuse me.
Why would the lack of duty matter for any claim unless it were a legal malpractice claim, a negligence claim?
Well, even for legal malpractice, that claim, should legal malpractice have occurred, wouldn't even belong to the plaintiff. It would belong to.
Sure, but that's my question. My question is, you point out that your clients owed no duty.
Correct.
Here, but which of his claims require that he prove a duty?
I believe there was there were a few negligent-based claims in his complaint. I believe one was negligent misrepresentation. I know that the two subject complaints are located on the record appendix, page 40 and page 50, and I believe they include some negligence-based claims. But either way, they should be dismissed. There's also a purported assault and battery claim, which stems from an event that occurred allegedly in open court while the plaintiff was testifying. Allegedly, he handed my client a sheet of paper. My client grabbed it, and somehow it caused some actual injury in the form of unwarranted folds in his papers and a scratch to his wrist. That was properly dismissed for two reasons. First, it fails to meet the jurisdictional requirements for superior court, as there must be a reasonable likelihood of recovery in excess of $25,000. That has not been alleged, nor do the allegations even support recovery in that amount. But secondly, and most importantly, what has been alleged does not even amount to an assault and battery under Massachusetts law, and the plaintiff has not put forward any supporting case law or evidence to the contrary. And with respect to our request for fees, we ask that this court affirm the lower court's fee award. Attorney's fees are mandated after successful prosecution of a special anti-SLAPP motion to dismiss, and that also includes appellate fees as well. And we also ask for double costs because this case is frivolous, and as Superior Court Judge Tepman noted, it was part of the plaintiff's pattern to engage in retaliatory and repetitive litigation, all in an effort to harass Jennifer, the plaintiff's ex-wife. And so we also ask for double costs pursuant to Massachusetts Rule of Appellate Procedure 25. And if there.
Thank you. I see that you're bringing it to an end, and with time left on the clock, we will move on to the next advocate.
Thank you.
Okay, who comes next?
I do, Your Honor. May it please the court. Nicholas Hawks, representing myself, Your Honor. Again, the Anti-SLAPP Act is essential and fundamental protection for attorneys. And this case is a prime example of why this act is so imperative, because absent this type of protection, there would be a chilling effect on the ability of attorneys to represent and defend victims of abuse. There would be, the motion judge was correct in this case when she dismissed all these frivolous claims brought by the plaintiff. The entirety of the conduct complained of by the plaintiff against me was petitioning activity. The petitioning activity arose wholly from statements and legal work that I performed on behalf of Jennifer Chalifo during the divorce proceeding. Now, if you look at the judge's decision, she carefully applied the burden shifting test. The burden shifted back to the plaintiff. The plaintiff failed to provide any factual support to overcome the burden. Every dismissed claim against me was based upon, as I said, my communication and my conduct as an attorney engaged in petitioning activity. In the event that the court is inclined, I'd like to transition to the litigation privilege. The litigation privilege exists to allow lawyers to zealously represent their clients without fear of reprisal. This privilege protects attorneys' statements while engaged in the fundamental function as an attorney during litigation. And it is a full and complete defense and precludes any civil liability. This coverage is essential to the necessary policy of permitting attorneys freedom and the ability to be communicative on behalf of their clients and to secure justice on behalf of their clients. I note that everything that has occurred during this purported suit occurred, as it relates to me, during the litigation. Nothing occurred outside the scope of litigation. As a result, I would ask this court to affirm the motion judge's decision. Thank you.
Thank you. And that brings us to the final presentation from Attorney LaGrasse.
Thank you, Your Honor. May it please the court. My name is Adam LaGrasse. I'm an attorney with the Law Office of Nicosia and Associates, and I represent the appellees Jennifer Shalafo and her father, James Cieslik. I'd like to, I think, focus on an issue that was raised by Mr. Shalafo. I think there's an important distinction to be made concerning the claims that were brought against my clients and how they came to be dismissed. Two of the three consolidated actions involve claims against my clients. Docket number ending in 2842 is the one that was dismissed under the anti-SLAPP statute based on my client's special motion to dismiss. The claims at issue there against my client were based on her seeking a criminal complaint and statements that were made in connection with probate court proceedings, which I think are very clearly petitioning activity. The other case, which I think Mr. Shalafo has somewhat lumped into the anti-SLAPP decision, docket number ending 1913, the dismissal was based on an allowance of our motion for summary judgment. And the allowance of that motion was based on Mr. Shalafo's failure to respond to requests for admissions and failure to respond to the statement of facts that was presented to the court. That case involves some of these other allegations that Mr. Shalafo has raised regarding this alleged relationship with a member of the Tingsboro Police Department. So I think that's an important distinction. Those claims, and I think Mr. Shalafo's brief seems to suggest that those claims were all dismissed as part of the anti-SLAPP decision, but that's not the case. There was two different decisions dismissing these claims against my client. And with respect to the summary judgment decision, Mr. Shalafo really has not argued in his brief any basis for overturning that decision. So I believe that he has actually waived any appeal from that decision by failing to present any argument there. And since there's limited time, I would like to address some.
Mr. LaGrasse, Judge Wolahojian who has a question.
I'm sorry.
Case number 1913, that was timely appeal and to this court, is that correct?
Yes, he did file a notice of appeal, but again, it really was not. I'm sorry.
And it's been consolidated within this case?
Yes, it's one of the three cases that's consolidated before the court. Yes. So I would like to just address a couple of the other issues that Mr. Shalafo raised in his brief. I believe he challenges the consolidation of these three actions. He really does not present any basis for any claim of abusive discretion there. I think it's clear that all of these cases arise out of the same general facts. At one point, these cases were all basically one case that was presented in New Hampshire before being dismissed there. And I'd also like to address the challenge to the order enjoining Mr. Shalafo from future filings. Again, I don't believe Mr. Shalafo's brief has demonstrated any abusive discretion in the entering of that order. It's based on the Superior Court's determination, based on the history of litigation, repeated findings that these litigations are intended only to harass my client. It's clear that there's been that awards of attorney's fees have not been a deterrent for Mr. Shalafo. There's been multiple awards of attorney's fees, yet he still persists. I don't believe the order is overbroad. It's limited to the Middlesex Superior Court and to actions arising out of the divorce proceedings and the claims that have already clearly been litigated. So again, I just see no basis to overturn that order. We have requested as part of our brief that my client be awarded her attorney's fees in connection with this appeal. I believe there's ample basis for doing so under the anti-SLAPP statute, as well as Mass General Law, Chapter 231, Section 6F for frivolous litigation. My client has been forced to expend lots of time and money defending these cases. I think that award is appropriate. So on behalf of my client,
we will leave it there. Your time has expired.
Thank you.
Thank you very much. Thank you all for your presentations and the cases submitted. That